Hello and welcome to this webinar organised by IFLA on establishing core principles for copyright in libraries. This webinar will focus on two recent statements that have been agreed by the Governing Board but prepared by our Advisory Committee on Copyright and Other Legal Matters. IFLA focuses on copyright because it's such a key issue for the ability of libraries to do their jobs. We often say it's one side of the same coin as funding. Of course, funding allows us to build collections, to buy licenses, but copyright is what tells us what we can do with it, how far we can provide access, how far we can allow users to extract value to achieve their goals, be it research, education, reading, cultural participation, or more. It's therefore a really important issue, an area where library associations have an important voice, representing actors, librarians who work with copyright day in, day out, who have a unique experience that it's really worth making sure is heard at these discussions. So in terms of our goals for today, there are two. Firstly, that we will present the two statements, and we're hoping that you'll come away with a much stronger understanding of why they're there, what's in there, the different questions that we raised, some of the discussions that we had internally while putting them together. And secondly, that you also start thinking about how you can use these statements. Okay, the arguments go with all IFLA statements, but in particular in this space, what can you do to use them in your advocacy? I think it's always worth underlining, remembering a quick little bit, why we actually make statements in the first place as an organization like IFLA. I know there's always the risk that we can seem quite far away, work at the global level, but ultimately we produce these things so that they can be used. So sometimes we do it in order to provide a formal statement of our views on a policy question, underlining that libraries have a voice, that libraries have something to say. It's a way of really showing that our legitimacy, the fact we do represent the field as a whole. Secondly, there can be processes, intergovernmental processes, where we need to set out a position, say what it is that we need. But crucially, we produce statements because they provide a reference point for our members. We know that similarly, just like us, for our associations, our members as well, making statements, setting out a position is clear so that others can engage with us. So through our statements, hopefully we give you a basis for thinking about, well, what can you say? How can you express your views, define your views in the first place? And so we very much encourage you to take these documents, translate them, adapt them into your own way, whatever will help you strengthen your impact, strengthen your voice. And finally, we also use them as calling cards. We still face the challenge where libraries, people don't expect libraries to be speaking up. They don't expect libraries to be part of debates. So this is a way of underlining clearly in a simple way so that other partners who may not have thought of the views of libraries, the role of libraries, the experience of libraries, so that they can actually see what we're about, what we need, what we want. So in this webinar, I'm really happy to introduce three fantastic colleagues who are really at the heart of putting together this work from the Advisory Committee on Copyright and Other Legal Matters. Firstly, we'll hear from Ibrahim Farah from the Lebanese American University in Lebanon. Then we'll hear from Rodney Malaysi at the United States International University in Kenya. And finally, we'll hear from Amanda Wackwork from the University of Alberta. So with that, thank you very much, and I will hand over to Ibrahim.
It's just like a good to start this way. So I would like to continue from where Stephen ended, that we are the statements are adopted by IFLA Governing Board. They represent the official opinion of IFLA. So libraries can use them to take decisions regarding to copyright, to collection, to providing access. And I will move from, so you can see now my full screen, yes, correct? Okay. So I will start with this quotation that will be the core of my talk. It will give you a balance between what is copyright and what is extreme copyright. So it is by Kim.com. He says that if you create something, you don't want someone else to go and profit from it. You have your right to make a living and everything. So I respect copyright. This is what we all do. We all respect copyright because creators are depending on copyright law to make a living, to be more creative, to produce new works. However, what I don't respect is copyright extremism. So when copyright is extreme, it will threaten what we are doing, providing access to knowledge and preserving access to knowledge for the new generation, for the upcoming generation. And what I don't respect is a business model that encourages piracy. So moving from this quote, what we can understand, actually, we are in a historical period now, and literally it is a historic period. It is the period where we have a big shift between on how education or how scholarly articles and books are produced and published. So previously we had the print type of materials, and copyright was adapted to print materials. So we enjoy exceptions. We have the first sale doctrine, where we can buy copies of books, provide access to these copies, and then use it as a copy that we own. Now we're shifting to a digital world. Everything is produced in the digital mode, and we have to reform copyright law so we can continue enjoying the exceptions we used to be enjoying previously. And this is what's actually happening around the world, and mainly in Europe. If you are aware of the Knowledge Rights 21 work, Liber work, Spark Europe, they are all having discussions trying to reform copyright laws, especially in Europe, to adapt copyright laws to the new era of publishing materials. So as an introduction, Stephen said that copyright law is a key determinant of how libraries can use their collections. So if we have the biggest collections in the world, the most prominent collection, but we don't have the right to provide access, what we can do with this collection? Nothing. So access is an important part, and to be able to provide access, we need a copyright law that give us the exceptions and the permission, or give us the freedom to do this, to provide access. Education, research, and culture are all embodied in the purpose of copyright, aligned with the interest of creators. So this is the balance we're talking about. So we have the interest of creators. They want to make benefit from their work, and it is like a motivation for them to continue to produce. And we also have an obligation as libraries to provide access to materials for education, research, and cultural reasons. So here, the updating of copyright law for the digital age is very essential. So we need to transition to a copyright law that can answer the challenges that we are facing now in the digital age. So many long-standing protections are now threatened. For example, if I want to give you a simple idea, we are trying to make this document as simple as possible so you can use it actually in your everyday work. So a simple idea is that previously you used to buy a book for the library. You are buying a copy. This copy you can lend it to users. You can sell it in a book fair, for example. So it is your copy. You can use it according to the exceptions provided by the law. However, now we are transitioning to a digital world where there's only one copy available, which is with the publisher. The publisher owns the copy, and they are licensing the copy for you. So you have to follow the terms of the license. And at any moment, they can stop access. So these are all challenges that we need to find solution to in the new digital world. Excessively strong copyright can undermine education, research, and cultural goals it claims to support. So excessive copyright will threaten our mission in providing access to materials for education and research and cultural goals. So in our opinion, copyright should be an enabler, not a source of fear. So we should, again, create this balance between giving the right holders their rights and enjoying our rights according to the exceptions provided by the law. So currently, it was always this way, we have an unbalanced relationship between large right holders and libraries. Previously, there was a status quo in the copyright law. We enjoy its exception, we understand the exceptions, so things were going in the right direction. Now, with the licensing world, where the power is in the hands of the publisher. So the license is everything. What they put in the license, we have to follow, and this should not be the rule. So we are in in an unbalanced relationship between right holders and libraries. So to create a balance, we need to reform copyright laws to continue to enjoy the exceptions we used to enjoy before. So what matters for IFLA? So what are our core mission as libraries? So we have two main core missions in libraries. One is to preserve, the other is to facilitate access. So IFLA supports that we continue to be able to preserve. Libraries need to be able to preserve. So the question is, how can we fulfill this duty in the age of licensing? So when we have a license and the copy is only available at the publisher's service, so how can library preserve a work for future generation, for 100 years to come? We don't have the copy available actually. So for example, I was thinking, is it possible, for example, to reverse digitization? So previously in the last couple of years or last decade, what we were doing as libraries, we were benefiting from the exceptions provided in some laws to digitize some materials for preservation purposes. So when we have a deteriorating book, we can digitize it and preserve it. So in this age, can we do the reverse? Can we print some books to preserve them, to have a copy for preservation? So this is a question to think about. Library also, in addition to preservation, we need to facilitate access for education, research, and wide public interest goals. So in order to facilitate access, we need to have a copyright law that allow us to enjoy the exceptions, to provide access to own copies, for example. And we need to make use of new technologies to allow for remote access. So if you all, of course, you all heard about the controlled digital lending dilemma that mainly was in the United States during COVID-19. So Internet Archives and Ashet where they went into a lawsuit related to controlled digital lending. So Internet Archives were lending digital copies to users, and this was considered an infringement of copyright law. So we need to have exceptions that allow us to provide remote access to collections. And the exception should be flexible to respond to new cases while following the principle of fairness. So what we have to focus on is not the instance. We have to stay in the concept of fairness, but we should be able to respond to new cases as they arise. Also, we need a permissive approach to out-of-commerce works and orphan works. So when a work is out of commerce, or when a work is not, there's no commercial benefits for the author anymore, they are not interested in reproducing the book or distributing the book anymore, and especially orphan works, we should be able to do more with these materials, more than what the law allows, because there is no commercial interest in the work. So we need a more permissive approach to out-of-commerce works. And lastly, exceptions should work across borders. So now, as you all know, copyright law is territorial. So when there's a breach, we use the law of the country where the breach occurred to conduct a lawsuit, actually. But we need to have exceptions that allow us to work across borders, because in the digital age, we're not limited to borders anymore. So what kind of reform is needed? From the discussions that are now happening in Europe, especially in Knowledge Rights 21 group, there are some concepts that we have included in this document. First one is that to include technology neutral limitation and exceptions in copyright laws. So if the law allows us to do something under an exception, we can, for example, provide access to a certain material under the exception. Technology should not disable us from fulfilling this exception. So the publisher should not be able to implement technological limitation to prevent us from enjoying this exception. Also, exceptions should be protected from contract override and bad practices in licensing, such as, for example, the choice of law clause. So in some countries, they have contract override law. Contract override law does not allow the license to override the terms of the contract. Sorry, the contract override law does not allow the license to override the actual copyright law. So even if in the contract we're not allowed to benefit from an exception in the law, if there is a contract override law, the license is terminated. It's considered obsolete because the law is superior in this case if we have a contract override law. However, in many countries there is no contract override law. This is why the license is actually what we rely on when deciding what to do. So many many publishers, they use licensing habits such as including a clause in the law where they can choose the law in play. So they can set that this license is in any conflict, we should follow the US law. So they choose a country where there is no contract override law. Technological protection measures that prevent the enjoyment of exceptions should not enjoy protection. So as I said before, we should not, the law should guarantee that any TPM, any technological protection measure should not enjoy protection. So if something is permissible by the law, if we can enjoy a certain exception, the technological measures should not disable us from doing it. Also, libraries should benefit from limitation on liability for copyright infringement and protection against unfair contract terms. So the library should not be liable for third user behavior. Let's say, for example, we have access to a certain collection and there's a bad behavior from a user that we have in the library. Then the publisher will stop access to the whole collection because one person has used it in a unlawful matter, in an unlawful way. So in the law, in the copyright law, libraries should benefit from limitation on liability. So we should not be punished for what third user is doing, the unlawful behavior of third users. And we should also address situations where libraries are denied access to materials, a necessary condition for the enjoyment of exceptions and limitation. So as you know all, that sometimes, and it happens a lot, that when a bad behavior, when the publisher monitor a behavior, for example, a huge download of articles in a certain institution, they stop access to the whole collection. So we should not be, libraries should not be denied access to materials, okay? And this should be guaranteed by the law. So to enjoy exceptions and limitation, we should be able to have access to materials, continuous access to materials. Okay, and copyright enforcement efforts should be proportionate, recognize the public interest role of libraries and the benefit of access. So copyright enforcement should not deal with libraries that have the public interest role, like the public interest as their mission, to serve the public in their mission. We should not be dealt with as a normal user who's breaching copyright. So they should take into consideration that the library have a public interest role to provide access to users. Before I finish, the functioning of information markets should receive greater focus from competition, given their impact on research and the power given to rights holders to restrict access. So as you can, this is revolving around the same idea, if I may say this, that right holders or big publishers, they have the power. Sometimes they have the monopoly over certain collections, and they can use this to deny access to libraries, or we cannot like negotiate prices as we want, for example. So they have the power over us. So so we should create this balance between publishers having monopoly over the collections and our job or our duty to provide access, and this should be guaranteed by the law. At the end, libraries should support fair distribution of copyright revenues to creators. For example, in some countries, we have the public lending rights, where public libraries, they count lending of books, and they pay authors or creators their shares of of lending. So if a book is lent 5 times, they pay a certain fees to the creator because their book has been used, has been lent for 5 times. Also, we as libraries, we emphasize the role of CMOs in gathering revenues for copyright owners and distributing revenues to copyright owners. So we need to give the right holders their rights, and we need to continue enjoying our exceptions in the new digital age. So this policy or this statement was agreed by IFLA on April 4, 2025, and it can constitute a base in your libraries, so you can know how to think about copyright, especially in this uncertain age of digital publishing. Thank you, and sorry for being long.
Thank you. That was an excellent presentation. So thank you so much. What I will do is head now straight on to Rodney, in order to talk a little bit about the AI statement. I can see some questions coming through in the chat, but we'll come to those at the end. So I'll now we'll go from the general of copyright to the specifics of AI. So Rodney, over to you.
Want to share the screen? All right. Okay, there we are. Yes. Okay, I'm going to discuss on the role of position statement on AI, and as far as IFLA is concerned, and why we need to actually plug in and know what the role is. So what are some of the reasons that we need to take a position on AI and copyright? The first one is that as libraries, we need generally to have a clear guidance on what we can legally do with generated content, whether it comes to acquiring or whether it comes to archiving or sharing or lending such materials without infringement. Because as we are coming up with the statement, we have to realize that having a position actually helps us to protect libraries from legal risks and ensure that we comply with the copyright laws. And at times, statements can actually help, like whenever there are sort of like some gaps, maybe in our statutes, which may not really adequately raise some issues as far as AI and copyright is concerned. Then secondly, libraries, as libraries, we do exist to provide access to knowledge and culture, and therefore a position on AI and copyright can actually help librarians across the board to ensure that we can responsibly offer AI-generated contents and tools, expanding access for patrons while respecting authors and creators' rights. Because as we navigate a lot of the digital content and also whatever is on our shelves and AI generated, we have an obligation towards the creators' rights. And therefore, we always have to protect them as ongoing tasks in our libraries. And a clear stance informs how libraries develop collections involving AI-created works and integrate AI tools like chatbots or recommendation engines into their services, balancing innovation with legal and ethical consideration. So therefore, we really need a clear stance in form of a working statement. Then as libraries, as we have worked through the years, we realize that we are advocates of our users' rights. And these rights may include fair use, and especially if you're using the American the British Commonwealth, majority of us may be using the fair dealing principle. So when it comes to that, then including fair use or exceptions in copyright law, a position on AI will help libraries to defend users' ability to use and interact with AI-generated content fairly. And then we also have a role as far as promoting ethical technology is concerned. Realize that information literacy is part and parcel of what the library does. So taking a position will actually be helping us to, to advocate for transparency, fairness, and responsible AI development and deployment. So once we have AI statements within our departments, then it should actually help us to do quite a lot as far as ethical technology use is concerned. And then AI technology, as we all know, is always developing quite rapidly. We may be at one stage here today as far as AI is concerned, but then when we move in a few days later, quite a lot will have changed. Therefore, having a clear and thoughtful position as a statement can actually help libraries to stay, it helps us to stay proactive and then quickly adapt policies. So you can imagine if maybe your copyright law or some statutes as far as AI change, yeah? So when you have policy guidelines or rather an AI a working principle from AI statements, then it can actually help us to proactively adapt those policies, be it clauses from our copyright laws in the different jurisdictions, wherever we are based. So rather than reacting to legal uncertainty or restrictive regulations after problems arise. So when you have a statement in place, we won't have so much of legal uncertainties as far as streamlining our tasks in the library are concerned, as far as protecting users' rights in AI and other copyright related issues. So challenges that may be faced due to lack of a position statement on AI and the copyright. Number one is that unclear rights to use of generated AI content. Libraries may not know if they can legally store, distribute, or provide access to AI-generated work. So without clear guidance, many libraries and information centers will be in limbo as far as how to legally handle and store AI-generated works. So having an AI statement works well in giving us, a framework through which libraries can navigate some of these legal risks. And then secondly, the challenge in collection development. There's a possibility that most of our libraries can struggle to decide whether to include AI-generated materials in the collections. Unsure if these materials have proper copyright protections or if they're in the public domain. So once you don't have that statement in place, then you won't stand guided as far as the collection development is concerned. So, and then there can also be challenges in supporting AI tools. And also issues with digitization and preservation. As far as challenges in supporting AI tools is concerned, libraries lately, they are starting to offer AI-powered tools for research, for learning. Think through some of the subscriptions that we have, like maybe Dimensions database, which has AI-powered tools, and also many of the generative AI tools that exist out there. So without copyright clarity, they might hesitate to provide these services or face legal risks if the AI uses copyright content without permission, like what some of the things which my colleague Farah had mentioned. So we can have as many tools in our departments, but then we can be very hesitant to navigate some of these tools because we do not have a policy whereby we can stand informed on how to make use of these tools. Then issues with digitization and preservation. Libraries will have a big task to archive or preserve AI-generated content responsibly, especially if the copyright status just remains ambiguous. So, and then quickly for library users, what are the challenges that library users may face without a statement in place? Users may not know if they can freely use material, share, remix the content. As you do this, I want you to think through the various Creative Commons licenses that exist out there. We may not, as library users, they may not know how to easily apply some of these, copyright protection logos on Creative Commons, because there is no statement. As librarians, we wouldn't have guided them in any way. And without clear rules, users might unintentionally violate copyright by using AI-generated content in ways that aren't allowed. Like lately when platforms like ChatGPT can allow maybe the generation of photos. And you see, a lot of this data has really been trained, on vast amounts of data. But when they train the data, it is quite possible that library users may download somebody's photos, and okay, if it is not actually used, then it may not really be infringement. But once maybe that image is used on maybe an assignment, or maybe when somebody was writing a book and they place it as a book cover, the library user may actually unknowingly infringe copyright. So when we have these policies in place or statements, they can help us to navigate some of these challenges on behalf of our users. And then users might be less willing to experiment with AI-generated content if they don't know the legal boundaries. And therefore, this gives a good framework, or actually gives us a good basis on which, like some of the AI policy, statement that we have come up with that some time back. Some of those kind of statements can actually help help our users to navigate such bottlenecks as far as legal boundaries are concerned. Okay. Thank you so much. Stephen, back to you.
Thank you. In fact, I'm going to hand straight over to Amanda, who will walk us through the statement as a whole. So, Amanda.
Yeah, thank you. Thank you to Ibrahim and Rodney for those fantastic presentations. Thank you to Stephen for helping organize today. It's a pleasure to be able to talk to you about the work of the committee and the statement that we prepared earlier this year. It's so much more useful to have this conversation in the context that the previous two speakers just provided. This is a very fast-moving time for libraries and AI especially, and how we use AI in libraries. And let's talk about what we created to help us navigate that, so that as library workers, we can make sure that we continue to serve our public interest mission. So what I have done in the next few slides is set out sort of the top level key messages in the statement itself. Now, the URL that you see on the screen and that you will see on every slide in this presentation will take you to the full statement. So keep in mind that these high-level sort of takeaways that I'm sharing with you on the screen today are in many cases further developed in the statement itself. So first and foremost, what the committee did when crafting the statement was think about considerations for libraries. So what's happening right now to change the way we need to think about advocacy and AI in our work. So right off the top, we decided that libraries need to be clear about supporting the training of AI and its use, especially in helping with our cataloging and collection and item discovery, services, improving all of the services, really, as we move forward and AI becomes more robust and more flexible, there is a role for it to help us really in delivering almost all of our services. So this is not a controversial statement for us, and we hope that being clear about this, that libraries support the training of IA and its use, that it'll become less controversial for those who may still be having conversations about where AI fits in their roles. So off the top, that's how we wanted to set the stage. We do recognize, though, that rights holders can and are seeking to restrict the use of content for training AI, and that could include some of the ways that libraries are intending to use AI. So we are at this point of tension where rights holders are nervous about the way AI may use their works, and that is a legitimate concern. But if those advocacy efforts and case law extends their rights beyond what libraries have historically been able to carve out as uses, we could be in a very detrimental position in terms of doing some of the good work that Ibrahim and Rodney have already described, like preservation, digitization, just serving the public in general. So we're at this point of tension. And we need clarity on how to move forward. And really, it's really useful to remind everyone that existing copyright law often supports innovation and the rights holders' rights writ large. So we just want to bring that top of mind, that perhaps there aren't massive changes in some jurisdictions that are needed to continue to support libraries and rights holders. So and I said in some jurisdictions, because that is the challenge with creating a statement that applies across many borders, is that we need to respect that individual countries may have developed laws that are a little different on this topic. So when existing copyright law supports rights holders and innovative technology, we need to point to that as something that's standing and that we need to not change, perhaps. So in addition, in many countries, legislation and principles related to AI also exist outside of copyright law. And this sort of extends that idea that we have legislation and other sorts of covenants that already support the type of concerns that AI is creating already. So often, if you talk to people about what is concerning about AI, they will speak to health, safety, privacy, ethical concerns, all of which are incredibly valid. However, copyright law does not help address those concerns. So there's some that feel that extending copyright law will help concerns that it was never set up to assist with. So it's useful to have that clear when you're developing your own AI policies or advocating for change. And finally, in terms of considerations, we are very clear that libraries should consider implementing and recommending to users AI tools with a values-driven approach. So that means considering the impacts of AI, considering how legislation might apply to uses, and that's, I think that goes without saying for all of the tools that we have in our remit, in photocopiers, audio recording material devices, that sort of thing. So the same applies to AI. It's a tool. And we want to make sure it's used to support library services, but not to unduly harm anyone, including rights holders. So that's sort of what's beyond that. All right, or behind that statement, excuse me. So those are the main considerations that we worked with as we developed recommendations. And Rodney was so good to talk about the importance of recommendations. So I'm sure you've been waiting now to see what we came up with. So first and foremost, we are recommending that libraries advocate for and inform decision makers about the benefits of expanding existing limitations and exceptions for research to permit uses such as text and data mining of legally accessed or acquired content. So this is huge. We want to make it clear that libraries are not the dominant rights holders, not the dominant beneficiaries of copyright law. We are working with carve-outs and exceptions and limitations. And we want to make sure that continues to support text and data mining, which is shortened as TDM. So if you see TDM, that's what this is about. We should continue to advocate for that. And related to that, libraries should advocate for the widest possible access to materials whilst observing fair and care principles, and to monitor AI services in libraries to ensure adherence to diversity and equitable access to information. So again, this values-based approach. For those not familiar with FAIR and CARE, these are principles, statements that specifically focus on data and rights related to data governance. CARE in particular is focused on data governance for Indigenous rights and related to Indigenous rights. And FAIR is more broadly looking at open access and data. So we recognize that a lot of good work has been done in this area, and we should lean on it and make it part of our decision-making process as well. So another recommendation for libraries is that we should be building capacity, raising awareness, and offering essential training on evolving technologies, including AI, clearly, to support employees, researchers, and other library users, including authors, which Ibrahim, very rightly pointed out, are users of these technologies and our content as well. So libraries should pay close or due attention to the transparency and integrity of AI tools as they develop or provide access to applying available good practice tools. So again, just repeating that we should not be using any tools blindly, including AI. And that means we need to learn a little bit more about what these tools do and how to set up safeguards before suggesting change in this area. Okay, so that's recommendations for libraries. We also had some recommendations for libraries that are active in advocacy work, and hopefully that's everyone on this call and everyone watching after the fact. So we recommend that libraries should encourage governments to be guided by existing human rights conventions in the development of laws and regulations related to AI. There's a lot of good work out there already that many advocacy organizations have contributed to over the years. I mean, the UN Declaration of Human Rights comes to mind. UNESCO's a really wonderful statement, a recommendation on open educational resources. There are so many things that perhaps the government employees that you're advocating with or working with may not be aware of. And it's up to us to make sure they understand that there are human rights related tools that can help inform any development around AI legislation and regulation. We should also be encouraging governments to support library and wider efforts to develop ethical practices related to concerns with AI tools. We know there are some very big players in this space right now, very commercial players that are advocating hard for what they need, and in the realm of AI regulation. And this can put them at odds with rights holders, and unfortunately, libraries might be lumped in with some of those more extreme requests. So, just to remind governments that that we are taking a values-based approach and need to be part of that conversation when regulation is unfolding. So, in addition, we would like governments and AI companies to make resources available to support repositories where copying of content for AI training purposes risks lowering performance for other users. So this is speaking to those safeguards that are informed by a balanced approach that support library work, but also give us some safeguards to be able to make sure that our work isn't unduly restricted by overuse. So it's a tricky balance, as I'm sure you've come to appreciate by this point in the webinar. So thoughtful advocacy is key. And finally, rights holders and vendors should not include language in contracts that hamper or unduly restricts the use of AI by library users or prevents the use of any applicable exceptions in copyright law. So this is in line with the spirit of the ICOLC statement on AI licensing, but it goes a bit broader than that. So this is not just governments we need to advocate with, but also the vendors that we work with. We need to be able to make it clear to them that the law, these very small carve-outs in the law, allow us to serve our users, and that they should not be putting up any barriers to that work. So I'm not sure how I'm doing for time. I'm right on my 12-minute mark, so I'm going to wrap up there and thank everyone again for giving me some space to share the good work of our committee over the last year.
Thank you so much. And there was such a clear presentation and running through some of those arguments. And I think in particular that attitude of saying this is a very high potential technology that our users do want to use, they do want to apply it, and they should be able to. And then it's a question of, well, what is the right approach to regulating it to deal with the harms, the problems that they ultimately are, and crucially, that we shouldn't automatically just reach for copyright as the answer in every situation. As often I said, from my experience around this, there's a tendency in copyright circles to see copyright as the answer for everything, and that's just not the case. Before we open up for broader questions, I wanted to ask our panelists just to say a few words about how you would see actually using both of these statements in your own advocacy work. Because I think, I said, one of the goals of organizing this webinar was to look at that question of, well, what can you do with these statements? They're not, if they just sit there on our repository, then they basically failed. We want them to be taken, we want them to be used, we want them to be referred to. So I think I'll start with Ibrahim. How are you planning to use those statements?
Yes, thank you, Stephen. So as I said in my presentation, those statements are made simple, short, so that you can put them on your desk. You make sure that IFLA is supporting those statements. So you're not taking a decision that libraries or the governing board of the libraries around the world are against. So to align our libraries around the world around the same way of thinking, this is advocacy, actually. So doing what the collective libraries or the IFLA is doing right. So knowing the right from wrong, it's like the Bible of copyright, the Bible of AI, and to align your thoughts with the thoughts that are approved by IFLA. This way you know that you are doing the right thing, actually, without being hesitant about something. So you can easily say that this is supported by IFLA, so I'm doing the right thing.
Excellent, thank you. I hope other people sort of take that it's something that you can use, it's something that you can refer to as that global point of view. Fantastic. Rodney, over to you.
Yes. What I think, my thoughts are, with the presence of such a statement, it gives libraries a framework of where to begin articulating the very many issues as far as AI and copyright are concerned within the library, because we would all agree that there is such an overload of information as far as AI literacy is concerned. So it's sort of like a wild world out there as far as AI is concerned. So we get lost, in the vast volumes of data. But having an IFLA statement for many of our libraries and information centers, it gives us a very foundational place on where to begin to create policies within our library as far as, collections are concerned, information literacy is concerned. At least everyone having that tool can begin developing some, workable policies within their departments. Yeah.
Excellent, thank you. And I like that as well. As obviously the statement that we've set out is not a description of national law, national regulation in every country of the world. That's not something that we are able to do. But if it's the thing that triggers that reflection and triggers that possibility to actually define policies at the institutional level that take account of national laws and national preferences, that's a really positive thing. And of course, I should highlight the work of IFLA's Artificial Intelligence Special Interest Group, whose members fed in on the statement as well as providing this much more sort of holistic, not just copyright focused view on how we might work with AI. Thank you, Rodney. Amanda.
Yeah, just to add on to those already very thoughtful, insightful statements or comments rather on how the statement could be used. It strikes me that you know, copyright law is international, right? Every country has something, and every country has libraries that are working to serve the public interest. So having a common voice is critical. Especially at this moment when I feel like copyright anxiety and chill, so not doing things that we are legally entitled or legally defensible actions that we can undertake is something else that feels pretty universal right now, and that's understandable in a world where things are rapidly changing and we don't have a lot of clarity from from maybe some parts where we would like more clarity, some parts of our ecosystem that we need more clarity. And I'm thinking here of our own institutions, not just governments. We have laws that actually, you know, might be sufficient in some countries for what libraries need to do, but in others it's not. And so it's complicated to say something that's universal here. But I do think the statement has thread that needle when it comes to advocating within your own institution to start talking about copyright and artificial intelligence and what that means. It also, as Stephen mentioned, will help other IFLA, you know, interest groups and areas start to work with the committee as they have been doing already, but as things evolve and get perhaps more complicated, we can continue that work. But personally, what I'm going to use this statement for, and what I hope others do, is in my own national advocacy work, speaking with government employees who may not be familiar with the work of libraries, or worse, may fail to understand at this point what the role is for libraries moving forward. And it's our job to educate them and make sure that they stay up to speed on the role of libraries and why we need to be the ones speaking up for our users as well, because their voice is limited right now on this stage. So that's what I plan to do is work this in where it's appropriate to my own Canadian Federation of Library Associations copyright committee work and wherever else it makes sense. Thanks.
Thank you, and I really appreciate that point at the end, and I think I know often there's a broader point about libraries' attitudes towards laws and moving us from ourselves from a position of simply accepting what we're given, and just sort of rolling over and taking it, and actually recognizing that we are uniquely placed to be able to assess whether the information and knowledge laws that we have right now, and in particular copyright, are actually working for users. Who else is actually going to do that? There'll be plenty of big companies, both on the rights holder and on the digital platform side, who will astroturf. Like astroturfing is, for those who don't know the word, astroturfing is when you pretend that you support organizations that claim to represent individual artists, small businesses, etc., smaller players, but in fact, it's just a voice for big players, the Googles, the motion picture associations, big content, big tech. That's astroturfing. We're an organization, we're not astroturfing. We're here for people, for organizations that actually are supporting users. And so the voice that we can bring is legitimate. We should never feel ashamed or hesitant about making that experience heard in those discussions. So those are fantastic. I just want to see if there are any questions. I've seen a couple of questions about recordings and certificates, so that's fine. I can see there was one question earlier about copyright laws around AI content, about books that either are works that either are entirely AI generated or which contain AI generated content. I'm conscious this is a hot topic at the moment. I don't know if anyone wants to jump in.
I guess Stephen is the expert in this area. So Stephen, you can answer it. I can answer it very briefly, which is usually copyright protects the production of the human mind. So when it is AI generated, it is most of the time it's not protected by AI, but Stephen can talk more about this since he's the expert here.
I mean, I
Yes.
can jump in and give
Yeah.
the preface to almost every copyright question is it depends. depends.
Are you a lawyer in disguise?
No, absolutely. And so important to stress that none of us can provide legal advice. But my understanding is that in most jurisdictions, what Ibrahim said is right on the money in that a solely AI generated work is not subject to the protections of copyright law. That's my understanding. And I don't know of any exceptions to that, but like I say, we aren't able to provide legal advice, certainly.
I suppose I'll just add by adding in on that, exactly. I think that there have been cases that underline that purely machine generated materials there. I think that the live question there is that we're not in a world where you're talking about purely human or purely machine generated. There are some fuzzy lines around how much machine generated content you have. And at what point do you actually draw the line? And so you end up with questions around originality and human input that remain to be achieved. I suppose a key question there is just to start with, is transparency over to what extent AI has been used? And that's not a copyright question. That raises it's a much broader question than that, but just having that clarity when an article, when a book, when a work is presented, to what extent AI has been used in the production. And that's not necessarily a good or a bad thing, but it is a transparency thing.
So I guess, yeah, I can add on this. People expect like an answer to it. So the answer is that if it is AI generated, it's not a production of the human mind, it cannot be protected. But when there is a lawsuit, people come with arguments. One of the arguments is probably the prompt is something creative. But also many lawsuits, they said that prompting is not a creative, cannot be protected. So in most cases, AI generated works are not protected by copyright law. So
Yeah.
if I can say this.
But as I said, no, this is not legal advice. Look at your national laws, consult a lawyer. Don't try to claim copyright on AI generated work until you've checked any of these things. But so I think we are now coming to time. I guess I would just offer Ibrahim, Rodney, Amanda, if any last sentence.
Just a last word that Amanda also talked about, that the Copyright Advisory Committee in IFLA is here to help the community of libraries. So if you have any question related to copyright, you can reach to us, and then we will discuss it internally and bring an answer that is a comprehensive answer, if I can say this.
I guess I would just add on that if you are able to attend WILIC this year in August, so that's the conference, the World Library Information Conference that IFLA supports, we do have programming. The committee does have programming that will speak to, among other things, copyright risk assessment and mitigation, which again is a universal issue right now. So if you're able to make it to WILIC this year, that's one of the sessions that you could attend, and we'd love to have you.
Excellent, babe. Good plug. Rodney, did you want to say anything more?
Not much. For me, I'll encourage all on these webinar to interact with that IFLA statement on AI, to have a look at it and just to try to engage with it more and more. Thank you.
Thank you, Rodney. So, in fact, what I'm just sharing up on the screen now are QR codes in order to actually access each of these statements. So top left, you've got the core principle statement, top right, the AI and copyright statement, bottom left, the pages for CLM, and in particular, so you can access the list of members. And then bottom right is the CLM mailing list, which we invite you all, if you're interested in joining that conversation, please do sign up for that. But we are at time. I'm conscious people have other things that they'll need to go and do. But with that, I just want to say thank you to everyone for coming along today. In particular, thank you to Ibrahim at the Lebanese American University. Thank you to Rodney at United States International University in Kenya. Thank you to Amanda at the University of Alberta. Thank you very much for your presentations. Thank you everyone else for coming along today. And as promised, we will get the recording up and shared as soon as we can. So With that, thank you everyone and have a good rest of your day.